Guardianship versus power of attorney. Planning for your child with disabilities before he or she turns 18. When your child turns 18, Utah law changes the rules. You may still be mom or dad. You may still be the person who knows the doctors, the medications, the school history, the daily routines, and the dangers your child cannot manage safely alone. But legally, your child is now an adult. Schools, doctors, banks, agencies, and service providers may no longer treat you as the automatic decision maker. That can feel absurd, especially when your child still needs help. But the law generally presumes that an 18-year-old has authority over his or her own life. If that presumption does not fit your child's actual abilities, you need a legal plan. For most families, the question comes down to two tools: power of attorney or guardianship. Power of attorney is usually simpler, faster, and less expensive. Your adult child voluntarily gives you, or another trusted person, authority to help with finances, medical issues, benefits, paperwork, and related decisions. But there is a hard limit. A power of attorney only works if your child has capacity to sign it. He or she must understand at a meaningful level what authority is being given and why. If your child cannot understand that, a power of attorney is not a shortcut. It is a problem. Guardianship is different. A power of attorney is based on your child's consent. Guardianship is based on a court order. If the court appoints a guardian, the guardian receives legal authority to make certain decisions for the protected person. That may include medical care, living arrangements, services, education, safety, and daily welfare. Guardianship is serious because it can limit an adult's legal rights. That is why it should not be used merely because it is convenient for the parent. The question is not, would it be easier if I stayed in charge? The question is, what authority is actually needed to protect this young adult, and what is the least restrictive way to provide it? Also, guardianship is not conservatorship. A guardian makes personal and welfare decisions. A conservator manages property and financial estate matters. Some young adults need both, some do not. Utah courts prefer limited guardianship when limited guardianship will meet the person's needs. That matters. The goal is not to take over your child's life. The goal is to create enough legal authority to protect your child while preserving as much dignity, choice, and independence as possible. Do not wait until the emergency room, school dispute, bank problem, benefits interruption, or medical crisis. Planning should begin before the 18th birthday. Some young adults need guardianship. Some need only a power of attorney, healthcare directive, supported decision-making, representative payee arrangement, releases, or other tools. But pretending nothing changes at 18 is a mistake.